Bonjour tout le monde. Hello, everybody. Welcome to today's online event featuring two knowledgeable subject matter experts who will be speaking about understanding the intersection of health and immigration law. Before we begin today's event, we'd like to begin with an acknowledgement that N4 is hosted at CHIO, which is located in Ottawa, Ontario. Ottawa is built on unceded Algonquin and Anishinaabe territory. The peoples of the Algonquin and Anishinaabe Nation have lived on this territory for millennia, and we honor them in this land. Their culture and presence have nurtured and continue to nurture this land. We also honor all First Nations, Inuit, and Métis peoples and their valuable past and present contributions to this land. My name is Andrew Tomeyer. I go by the pronouns he, him, and I'm the education coordinator with N4. I will be hosting and moderating today's webinar presentation. My co-host is Mariah Maddock, who will be monitoring the Q&A box today. I'm pleased to introduce you to today's speakers, Nicholas Hersh and Laïla Demirdache. Nicholas Hersh is an immigration and refugee lawyer at Community Legal Services of Ottawa, CLSO, and a professor of Refugee Sponsorship Support Program course at University of Ottawa, Faculty of Law. He's worked extensively in refugee private sponsorship since 2010 with Capital Rainbow Refugee, a community group committed to providing a safe haven for LGBTQI+ refugees. He previously worked in the Protection Division of the UN High Commissioner for Refugees, UNHCR, in Rabat, Morocco. Nicholas has published in peer-reviewed journals on credibility and evidentiary challenges facing LGBTQI+ claimants in refugee law, as well as a chapter in improving UNHCR protection services for LGBTQI+ refugees. In 2017 and 2018, he delivered professional development trainings to the IRB adjudicators, registrar staff, and research director on Guideline 9, proceedings before the IRB involving sexual orientation and gender identity and expression. Laïla Demirdache has been working as a staff lawyer at CLSO since 2002, where she practices immigration and refugee law. Ms. Demirdache is a member of CARL, the Canadian Association of Refugee Lawyers Budget Implementation Act Working Group, and was one of the co-chairs of the CARL's Detention Working Group. As well, she's a member of several committees, including the Canadian Council for Refugees, Legal Affairs Advisory Committee, and the Inland Protection Steering Committee, the Ottawa Legal Aid Area Committee, the Immigration Law Legal Aid Area Committee, and the Ottawa Immigration Conference Organizing Committee. Ms. Demirdache was a member of a legal team representing Amnesty International Canada on several occasions before the Supreme Court of Canada, and most recently before the Ontario Court of Appeal. She's also appeared before the SCC on behalf of the Center for Victims of Torture and the Barbara Schlifer Clinic, and on behalf of CARL before the Federal Court of Appeal. Ms. Demirdache is also often appointed by the IRB to act as a designated representative for minors and persons with mental disabilities who have a hearing before the IRB. Due to the extensive content that will be discussed, today's session will be extending to 2:30 p.m. today. And for those that may have to leave early, it is being recorded and will be uploaded to our N4 platform within the next week or so. We will share this with you as soon as it becomes available. Should there be any technical issues during this webinar, we'll inform you with details for an alternate makeup session. Before we begin today's event, I would like to take a moment to introduce you to our platform features to help enhance your participation experience. Throughout today's session, we invite you to write your questions in the Q&A window. We know that sometimes many of you might have the same question or be interested in a particular response. Today, you have the option of upvoting a question. Please upvote questions you're interested in hearing the answer to, and we'll prioritize which questions we pose to the speakers first. Our speakers today have no conflicts of interest to declare. And with that said, I will pass the virtual podium over to Nicholas and Laïla. Thank you.
Thank you.
Thank you. It's nice to meet everyone. It's definitely a pleasure to be here. As Andrew mentioned, Laïla and I are both immigration lawyers at one of the community legal clinics here in Ottawa. We're especially excited to do this presentation today because, as you'll hear, we collaborate very often with medical professionals like yourselves for our common clients. So it's a pleasure to be here. Let me pull up the PowerPoint. Okay. So today's presentation is on immigration and refugee law as it intersects mainly with mental health evidence, although we'll also talk a bit about medical evidence in general. It's important to know that immigration and refugee law is really, really broad. So we're just going to focus on the areas of immigration refugee law that we practice at our clinic and we think are most important in terms of medical evidence. We obviously won't be able to get through everything, but you do have our names and emails here. We'll just say at the outset that if ever you have any questions on any cases you're working on or just want to learn more, definitely don't hesitate to reach out to us. Our virtual door is always open.
Always.
So I apologize, I'm getting distracted because I don't know where the camera is. It's over there. Okay. So the outline of our presentation is as follows. We'll start with a broad overview of immigration refugee law and the relevance of mental health evidence. We'll go through mainly refugee claims, what are called humanitarian applications, detention reviews, and inadmissibility. Time permitting, we'll talk about some strategies in preparing medical evidence and to make sure they have the most value in immigration proceedings. And then we'll have some time for some Q&A.
And we'll be talking, as Nick mentioned earlier, about mental health and physical health, so medical reports in general. So we are staff at community legal clinics. There's 73 legal clinics throughout Ontario. They're funded by Legal Aid Ontario. And our mandate is to represent people who do not have the means to represent themselves. So the eligibility criteria is a financial criteria that's set by Legal Aid Ontario on a yearly basis. We provide legal advice, summary advice and representation. We do public legal education, and we also are actively involved in law reform. The areas of law of the clinics of a community clinic like ours are landlord tenant, so housing law for tenants, disability law, access to social services, including also access to employment insurance and workmen's compensation, and finally, in immigration and refugee law. Next.
Okay, so usually our clients have at least one of four goals. Either they or someone they know want to come to Canada on a temporary or permanent basis. They want to stay in Canada for a longer period or permanently. They want to be what's called not found inadmissible, which we'll go into a bit, so that they continue staying in Canada and maintain their status and not get deported from Canada. So usually if a client has a question or a goal that's not related to one of these four, it's probably not about immigration refugee law. Immigration law is all about status. One of the first questions we always ask our clients is what their status is. Sometimes we can figure out what their status is based on the documents they may have been issued from Immigration Canada, or now known as Immigration Refugees and Citizens of Canada. So they may have what's called a temporary resident visa, which is more colloquially known as a visitor visa. They may have a work permit. They may have a study permit. They may have what's called a temporary resident permit, which we won't get into now, but it's basically a special type of document to give someone temporary resident status if they're inadmissible to Canada. Or if they have made a refugee claim, they have what's called a refugee claimant document. Status is especially important to know if someone has healthcare coverage. Many of you may be aware of the federal government's interim federal healthcare program. And eligibility for that depends on your status in Canada. So if ever you're unsure what a person's status is and they don't know as well, ask them to see what documents they may have been issued. And obviously, if it's still unclear, then contact us or contact one of the community legal clinics near you. Immigration law is generally divided into three different pillars. The first is what's called the family class pillar. One of the goals of immigration is to reunite families. And generally speaking, this is when someone can get permanent resident status as the family member of a permanent resident or Canadian citizen. There are also what are called economic class based applications. So this may be where someone can get a work permit or permanent residence based on their level of education, their level of English or French, or their educational background. And then the last, which is the one we focus most on at the legal clinic, is the refugee humanitarian class. So this may include people who arrive in Canada and then claim refugee protection. It may include people from outside Canada who say they're refugee and have been approved and then come through either a government stream or a privately sponsored, a refugee private sponsorship. It may include individuals who are applying for permanent residence on humanitarian and compassionate grounds, which we'll talk about in a bit. And finally, what are called pre-removal risk assessments, or PRAs. So we'll get into mainly this last pillar for today's presentation. So we'll begin with the refugee claim process, because I imagine for many of you, you're working with people who have claimed refugee protection and are either going through the system now or may have in the past. Generally speaking, to claim refugee protection in Canada, you need to fill in forms. Usually they elicit your biographical information. You'll eventually have an interview with IRCC, or Immigration Refugee Citizenship Canada, to determine you're eligible to claim refugee protection. By eligible in this case, I mean basically you're allowed to make a refugee claim. There are some cases where individuals are not even allowed to make a claim. And assuming you're eligible, you'll eventually have a hearing before the Refugee Protection Division, or the RPD. So this is a section of what's called the Immigration Refugee Board, which is the largest administrative tribunal in Canada. And the RPD is responsible for deciding refugee claims, among other things. There are usually only two decisions the RPD can make. One may be a positive decision, which is the RPD says the claimant or the client qualifies as a refugee. That's obviously the good news part. Or the decision may be negative, where the member says this person does not qualify for refugee protection. In both cases, the member, and by member I mean sort of like the judge or the decision maker, they need to explain their reasons for accepting or rejecting the case. And for most people who are rejected for refugee protection, they do have a right to appeal to what's called the Refugee Appeal Division, which is also a section of the Immigration Refugee Board. So I'm going to give you a crash course of the refugee definition. This is something we spent an entire semester, sometimes 2 semesters, breaking down, but I'm just going to explain it to you in broad strokes. There are 6 elements of the Convention refugee definition. So we say it's the Convention refugee definition because it comes from the UN Convention related to the status of refugees, which came out in 1951. The first criteria is you need to be outside of your countries of nationality. This is usually pretty easy to prove. If you're in Canada and you're not a Canadian citizen or permanent resident, you're outside your countries of nationality. For stateless individuals, if it's someone who does not have a country of nationality, then they need to be outside their country of former habitual residence. And there's obviously a legal definition to that term. You need to demonstrate you have what's called a well-founded fear. So this is a bipartite test. The first part is a subjective fear. One of the first questions a decision maker asks is, what do you fear in case of return to your country? And you need to prove that fear has an objective foundation, or it's well-founded. As a very quick example, let's say I'm gay. I say I'm afraid to return to my country because I'll be put in jail, I'll be tortured, people will assault me. A decision maker may say, I believe you fear that, but I don't believe there's an objective foundation because I reviewed the human rights documentation, I reviewed your testimony, and to me, I don't find that there's a reasonable chance that what you fear will actually happen to you. So when a decision maker is talking about that, they're referring to well-founded fear. You need to prove that your fear of harm amounts to persecution. So persecution generally means a serious harm that infringes on your fundamental human dignity. So not all forms of harm amount to persecution. You need to prove your fear of persecution is tied to at least one of 5 grounds. So race, religion, nationality, membership in a particular social group. So this could include gender-based cases or sexual orientation cases or political opinion. You need to demonstrate that there is no state protection for you, that you are unable or unwilling to solicit the protection of your home government. And finally, there's what's called no internal flight alternative. In other words, is there another place in your country where you can safely and reasonably live? And that's determined largely based on the country condition research and the applicant's personal circumstances. So again, that's refugee claims in a nutshell. And then I'll turn it over to Laïla to talk about humanitarian cases.
So the brunt of our work, I would say, and the bane of our existence are applications for permanent residence on humanitarian and compassionate grounds. You will often hear it referred to as an H&C application. And that's an application where the person is claiming that they don't fit into any of the other categories. And to have to make that application for permanent residence from outside Canada would cause too much hardship. So, and I'll give you a simple example. I have a client who just got a permanent residence on H&C grounds. Her application was approved. She was married to a Canadian. She had a Canadian child. The child wasn't born in Canada, but got Canadian citizenship through the father. They moved to Canada. So they met overseas. The child was born overseas. They moved to Canada. And before he could sponsor her as a member of the family class, he returned to his home country because his mother was ill. And then he contracted malaria and passed away. So she was in Canada and did not fit into any of the economic classes, did not fear persecution if she was returned to her home country, but it was in her child's best interest for him to grow up in Canada. So we put an application for permanent residence on humanitarian compassion grounds in. Next slide. So there's three general categories of factors that will be examined by the immigration officer who makes that decision. And just to note, you can make an application for permanent residence on humanitarian compassionate grounds from inside Canada, but you can also do one for overseas. The ones about overseas are less likely to succeed. It's hard enough to have your H&C approved from within Canada, but outside Canada, it's even more difficult. It doesn't mean that we don't do them, and it doesn't mean that they don't succeed, because we have had success rates with those. But it's three different categories of factors that they'll look at. The first one has to do with establishment. So they'll look at the length of time you spent in Canada, your work experience in Canada, your financial resources, your community involvement. So are you actively involved in the community? Are you getting community support? They'll look at also in terms of establishment in friends and family. Then there's the best interest of the child, and that's the best interest of any child affected by the decision. So it doesn't have to be a biological child, and it doesn't have to be a child who lives in Canada. So I've had clients who we've argued that it's in their best interest that they be allowed to get permanent residence in Canada because they're working and they're sending money home to their family and the children overseas. And that money that's being sent is very important for the best interests of those children. And finally, they'll look at the hardships of removal. So why would it cause you hardship to go back to your home country? So they'll look at the circumstances in the country of origin. Now, you can look at country conditions in terms of economic discrimination. They're not looking at risk, that's a refugee claim. They're just looking at hardship in terms of country conditions. If there's general insecurity in the country, you still have to show that you personally will suffer hardships and having to go back. And in hardship of removal is where medical reports become very important, because the case law in Canada is that they have to look at the impact of removal on that person's health, be it physical or mental health. So when we ask for medical reports, we're asking what would be the impact of removal on that person or on another person that is associated with our client. So for example, if our client is a caregiver for someone, for a family member who has a medical situation and would need that person's support with them. So we look at the impact of on the person's mental and physical health of being removed and of anybody else. I don't know what happened to my... Sorry, I lost my camera, went off. Now, the thing that's important to know about a humanitarian and compassionate grant or an H&C application is that it's not free. You have to pay $550 per adult and $150 per child. It is, so it can be expensive, and most importantly, it does not automatically stop your deportation from Canada. Unlike a refugee claim where the government cannot move to remove you until a decision has been made on your claim, an H&C does not automatically stop removal. And so we have to actively, if removal starts while an H&C is pending in the system, we have to actively try and stop that. And H&Cs can take up to 36 months to be decided. Now, the next thing we wanted to talk to you about is that people in Canada, so non-citizens, permanent residents, or people who are here with a temporary resident status, can lose that status and face removal from Canada. Next slide. So there's different ways that you can be found inadmissible to Canada. And if you're found inadmissible to Canada, then the government can proceed with your removal. There's categories of them. So there's one that has to do with a security, and those would include, sections, we put the sections of the act, but it has to do with security, human rights or international human rights violations, serious criminality and organized criminality. There's medical inadmissibility, and we're going to Nick is going to be talking about that in more detail. I'm going to be talking to you about criminality, serious criminality and criminality. There's financial inadmissibility. So my client, for example, whose husband passed away and whose H&C we won, we had to address the fact that she was potentially financially inadmissible to Canada because she was on social assistance at the time of the application. Misrepresentation. And that's misrepresentation, whether intentional or not. Non-compliance with the act, so people who stay beyond the validity of their permit or who breach it in some other way. And Section 42 of the act is an inadmissible family member, and so we call that the bad apple provision. So if you or any one of the members of your family is inadmissible to Canada, then the whole family becomes inadmissible to Canada. Next slide. So like I said, we're going to be talking about criminal and medical inadmissibility. And so the first thing to know is that you can become inadmissible to Canada for criminality or serious criminality. And what's important to note is this: it does not affect citizens in any way. A permanent resident of Canada can be found inadmissible to Canada for serious criminality, but not for criminality. So only foreign nationals can be found inadmissible to Canada, can lose their status or be refused entry to Canada because of criminality. A foreign national and a permanent resident or a convention refugee can be found inadmissible to Canada or can lose their status because of serious criminality. And the difference between serious criminality and what makes you inadmissible as a permanent resident for serious criminality has to do with the sentence, the maximum punishment that you can get. So if your sentence that you could get, so let's say for robbery, is 10 years of imprisonment or more, you're inadmissible to Canada, even if the actual sentence was less than 10 years. And the other way you can be found inadmissible to Canada for serious criminality has to do with this length of the sentence. So if you're sentenced to a term of imprisonment of 6 months or more.
Just to add on top of that, so when we're talking about offenses in Canada, you have to actually have been convicted of those offenses. So often we'll work with clients who have been charged, with offenses that, if conviction comes, would lead to serious criminality. But if someone is found not criminally responsible or NCR, that would not trigger criminal inadmissibility or serious criminality.
And also youth charges, youth convictions are not, you won't be found inadmissible for serious criminality for youth charges unless you've been sentenced in adult court.
Okay, so I'm going to briefly speak on medical inadmissibility. Also, as we mentioned, we'll take questions at the end, but if you have questions that come to mind, feel free to just put them in the Q&A and we'll monitor them and try to weave them into our presentation. So medical inadmissibility, there are three different grounds of this. First is a medical inadmissibility where you have a medical condition that's a danger to public health. The second is a danger to public safety, or you have a medical or health condition that might reasonably be expected to cause excessive demand on health or social services. I just wanted to flag as well that medical inadmissibility and also certain other types of inadmissibilities do not apply to refugees. So just keep that caveat in mind. In terms of a health condition that's a danger to public health, this would, for example, be untreated syphilis or active tuberculosis. I've never had a case where someone actually was refused or lost their status due to this section of medical inadmissibility. I found what happens more likely is if someone is found to have a condition, then they get treated and then they're no longer considered inadmissible for health grounds. I think it'll be interesting to see if COVID one day, probably sooner than later, would trigger this part of the act. I don't know if Laïla have thoughts on that, but it'll be interesting to see.
I think they would do something probably equivalent to the tuberculosis, where they would wait for the treatment.
Yeah, like a case I had of a refugee claimant who was found with active TB. He was just, I think, treated at the hospital for several weeks until it became passive.
Yeah, and they do require you to do follow-up checkups to confirm that.
Yeah. The other part I wanted to flag to you is the excessive demand provision. So basically the idea behind, well, the premise behind this is that if you have a health condition that's too taxing on the provincial healthcare system, then you shouldn't get permanent residence. Up until probably a couple of years ago, the threshold for determining that cost was really, really low. I think it was around $5,000 per year. And so if you or a family member had a health condition that cost that much money, you would not be allowed to get permanent resident status. A lot of advocates rightly called out the government for this provision being quite discriminatory to people with disabilities. So a couple of years ago, they upped the threshold to about $20,000 a year. And that cost is based on healthcare services. So if you have special education needs or personal support services or vocational rehabilitation services, the cost of those are not part of the calculation of the $20,000 per year. There's still some movement to just totally repeal the provision, which I'd be in favor of, but in any case, it's still in the law today. And if you have clients that may meet that $20,000 per year threshold, then there is a risk of them being deemed inadmissible for medical reasons.
Often, if there's a potential that you or a family member will be found inadmissible to Canada for on medical grounds or financial grounds, misrepresentation, they will provide you with what's called a procedural fairness letter, which indicates that there's a potential inadmissibility, and they ask you to respond to that. And we work a lot on those responses. In terms of the excessive demand, one of the things that's helpful is if our client is working and has private medical, like through their employer, has medical coverage.
Yes, but it has to be employment insurance. So we don't have to get into the nitty-gritty, but if you have to someone pledging to pay for it, generally the government says that's not enough because someone could always go on OHIP to access those services. Also, again, I don't want to get too deep in the weeds, but for these types of inadmissibilities, as Laïla explained, you can do a permanent residence application on humanitarian compassionate grounds. But if someone is doing a different type of permanent residence application, and they're inadmissible, for example, for medical reasons, you can ask for an exemption from that part of the act on humanitarian compassionate grounds. And you would include the same factors that Laïla outlined.
And the only other point that I would add to that is that sometimes we have clients who are worried about the medical inadmissibility, and they'll say, well, I don't have to go for treatment. And it's not whether or not you're actually getting treatment, it's whether you could get treatment. So I tell my clients, you're in no, I never want you to not get treatment because you're worried about this.
Yeah, there are ways to get around this inadmissibility if it is triggered. But again, now that the threshold is up to $20,000 per year,
We're hoping.
I think most medical conditions are no longer going to meet this part of the act, which is good.
So now we're going to be talking about getting deported from Canada and the process.
We try to avoid.
That you want to. So inadmissibility is for people who want to come to Canada or people who are in Canada. If you want to come to Canada and you're found inadmissible, they just won't issue you the visa that you need to come to Canada. But if you're in Canada, there's a procedure to, once you're found inadmissible, to remove you from Canada. Next slide. So what happens is that the way that it works in a nutshell, and it's not listed here, but the way that it works is that Canada Border Services Agency will write a report, and in the report will set out the allegations as to why they believe the person is inadmissible to Canada. There are, based on that report, they will then issue a removal order, and there's a variety of different removal orders that are way too complicated to get into here today. But you are issued a removal order, and there's some that CBSA can, and that's Canada Border Services Agency, can issue themselves, and others that have to go to the Immigration Division for the Immigration Division to issue that removal order. And so, for example, any removal order against a permanent resident of Canada has to be issued by the Immigration Division and cannot be issued by CBSA. But once a removal order is issued, in most circumstances, you have a right of appeal as a permanent resident or as a convention refugee to the Immigration Appeal Division. And if you don't have a right of appeal, sometimes you can judicially review that removal order. But if it's enforceable, then they can act on its removal. And if we go back to the previous slide, what happens is that based on that removal order, if CBSA believes that you may not report for removal, you can be detained. So we have people that are detained in Canada on immigration hold, and basically you can be a foreign national and a permanent resident of Canada can be placed in detention for 3 reasons. One, their identity cannot be established, and that's often it's people who have come to Canada to make a claim for refugee protection, where the government is not satisfied to their identity. There's where they're a danger to the public. So people with a criminality are often held in detention because of a concern for danger to the public. And the last one is what I said is flight risk. So either that you will not show for removal, or you won't show for a hearing that you may have before one of the divisions. When a person is held on immigration, so CBSA is the authority that decides to detain, but then that detention, once the person is detained, is reviewed by the Immigration Division of the Immigration and Refugee Board, and they review the detention. By law, they have to review it within the first 24 hours. Then they have to, 48 hours, sorry. Then they have to do it after 7 days. And then thereafter, it's every 30 days. If the detention is well-founded, you can still get your client out of detention if you could present an alternative to detention that will allay the ground of detention. So if the ground of detention is flight risk, then you want an alternative to detention that's going to address that issue. If the ground of detention is danger, then you're going to want an alternative to detention that's going to address danger, etc.
Yeah, and medical evidence for an alternative to detention is really vitally important. You know, if someone has a psychiatric condition, for example, and Laïla, as she mentioned earlier, works a lot as designated representative in detention reviews. often the challenge is finding medical professionals to do a proper diagnosis, especially in Ottawa, it's quite difficult. But getting a professional opinion as to the services a person needs as part of the alternative detention plan.
And it's important to know that depending on where you are in the country, the person can be detained at an immigration holding center, of which there's one in Laval, Quebec, one in BC, and one in Toronto. But if not, they're held at provincial facilities. So in Ottawa, for example, everybody on immigration hold is detained at the Ottawa Carleton Detention Center unless they can get them to the immigration holding center in Laval. And so it's important to know that you've got refugee claimants, you've got people who are not criminals that are being held in a prison facility and treated like criminals, even though they haven't done anything, but they're on immigration hold. And sometimes that's very difficult for them to deal with. And the problem is if you have a client in an, let's say, for example, at Ottawa Carleton Detention Center, getting an assessment for your client is exceedingly difficult because you have to get that medical professional into the detention center.
Yeah, especially during COVID.
It's non-existent.
Even before COVID, it was exceptionally challenging.
Okay, so like I said, in most circumstances, your removal order as a permanent resident or a convention refugee can be appealed to the Immigration Appeal Division. And the reason why that right of appeal is really important is because the Immigration Division is only looking at the facts of the case. You can't present humanitarian compassionate ground to or explain the circumstances of the criminal conviction. So for example, if I have a client who's been found inadmissible to Canada because of serious criminality, a permanent resident of Canada who's been in Canada for 20 years and who suffers from mental illnesses and concurrent disorders, you know, the reasoning or the medical circumstances, the family circumstances, none of that is relevant for the Immigration Division. The Immigration Division just needs to confirm what your name is, your date of birth, the fact that you're not a Canadian citizen, the fact that you have been convicted of this offense, and that's it on such and such a date. It's 20 minutes, it's open and shut. So there are other, if you're arguing that you're not a member of an organized if it's organized criminality, then you can get into the facts of the case as to whether or not you are a member of an organized criminal group, but or misrepresentation, whether you did or not. But if not, the humanitarian and compassionate is at the Immigration Appeal Division. So they will look at the IAD, as we call it, will look at the legal validity of the decision. So you can challenge the legal validity of the removal order. And then they will look at whether there are humanitarian compassionate circumstances or grounds to suspend that removal order, or to either stay the removal order, suspend it or stay, or to cancel the removal order and dismiss the that removal order, quash it is legal. And so what they're looking at it are all of the circumstances of the case, including the best interest of any child that is affected by the decision. It very much is related to the H&C factors that I mentioned for applications for permanent residence on H&C grounds. And where criminality is involved, often what they do is they put them on a stay of removal on terms and conditions. And so, for example, I tell my clients it's like immigration probation. So you've got criminal probation and immigration probations. There's rules. You have to keep the peace and be of good behavior. If you have medical reasons or medical issues, often what they'll say is that you have to follow the directions of your medical team. So the treating physician or psychiatrist and the medical team, to ensure that your mental or physical health doesn't put you in a situation where you would reoffend. et cetera, et cetera. And it's important to know that the immigration appeal is not just for criminality. You can appeal a deportation order for failure to comply with the act. That's often for people who've left Canada for longer than they should have, so they didn't comply as a permanent residence with the terms of that. For people you've applied to sponsor and that sponsorship has been refused, and misrepresentation, criminality, and you don't often see appeals for financial or for sorry?
For misrepresentation?
Or for misrepresent. Well, no, you do for misrepresentation because of the sponsorship fraud.
Okay. Yeah.
So I did one. It was a long case.
Okay. And we'll conclude the substantive part of today's presentation on pre-removal risk assessments, or PRAs. So not all, but generally speaking, an individual cannot be deported from Canada unless their PRA has been refused. So just kind of following the example that Laïla had, let's say you're a permanent resident, you've been convicted of certain acts that result in serious criminality, you appeal that to the Immigration Appeal Division. For one reason or another, your appeal is eventually dismissed, or what sometimes happens, especially with our clients with mental health, is they don't show up for their hearing, and then it's deemed abandoned. That person cannot actually be deported until their PRA is issued and is decided. There are tight deadlines for PRA, so if ever you have a patient or a client who is eligible for one, it's really important to make sure they get legal assistance with that, because if they don't meet those deadlines, then they can be deported, even if they ultimately do the PRA. Generally, the criteria for a PRA is the same as a refugee claim. So it's that well-founded fear of persecution based on one of those 5 grounds. But it's generally the same criteria, but the application looks a little bit different. So for example, if you are doing a PRA and you had previously made a refugee claim, you can only present what is considered new evidence that you could not have reasonably provided at the time of your refugee claim. So maybe there's a new risk that came out, after your refugee claim was decided. Maybe there are new events in your country that are relevant to you that didn't happen at the time of your refugee claim. You need to make the case that this new evidence is admissible because you could not have provided it earlier. In most circumstances, PRA applicants do not have a hearing. There are obviously some exceptions to that. And if the PRA is refused, then CBSA, meaning Canada Border Services Agency, can now lawfully deport you. There are ways to stop that deportation. Usually it involves going to the federal court and asking the federal court to intervene and stop that removal until a certain date in the future. I can tell you the approval rate for PRAs is quite low, especially for people who previously made refugee claims. I think it's around 5%.
I think it's lower.
What is it?
It's lower.
Lower than 5%?
For the previous claims, yeah.
Okay. It's really, really low. So it's all to say that, getting someone status from the refugee claim from the start of their legal proceeding is really important, because if you reach the PRA stage, it's really hard to, not impossible, but really hard to help the person remain in Canada and get back into status or get status to begin with.
And sometimes strategically, we know that we won't win the PRA because there's not, especially for people who's already had a claim before, or someone who, would actually not face risks if they went back to their home country, but their H&C application is very strong. And so what we do is we file both at the same time, because the PRA will stop removal, but as I mentioned earlier, the H&C will not stop removal. So we submit both, we ask that the same decision maker look at both, and often if they're going to approve it, what they do is that they suspend the H&C and say, well, we don't need to decide it because we've approved your, they suspend the PRA, because they say we've decided to approve the H&C, which also keeps the statistics of the PRA down.
Yeah. But again, the PRA is usually the only type of application that lawfully allows a person to not get removed from Canada.
Apart from the ref claim.
Apart from the ref claim. It's usually the last recourse before someone can get removed. Okay, so we've explained a lot of the different types of immigration applications we do. Now, what's the role of medical evidence? So go ahead, Laïla.
So it's very important. We work very collaboratively with the doctors that are involved in the doctors, nurses, social workers, the medical team that's involved in our clients' cases. And where that happens, we're more likely to succeed than if we're working in our bubble alone. It can support an application, a refugee claim. It can support an application for permanent residence on H&C grounds. It can support PRAs. It can support an alternative to detention. It can support sponsorship applications. There's a number of applications, ways medical evidence can be very useful. Where the person has a hearing, so at any time that you're appearing in front of the Immigration Refugee Board, either for Immigration Division, the Immigration Appeal Division, the Refugee Protection Division, or the Refugee Appeal Division, medical evidence can be very important in explaining testimony. Because as Nick says, so if you take an example of someone who's making a claim for refugee protection on the basis of their sexual orientation, and let's assume that the country that they're going to, there's a lot of objective evidence that would support that they would face persecution if they went back, the Refugee Protection Division still has to determine if you're telling the truth. Are you actually someone whose sexual orientation would put them at risk? Are you actually a woman who's fled a situation of domestic violence? Or are you just saying that so that you can get your claim approved? And so if your client, me as a lawyer, Nick does the same thing, if we believe that our client may have any trouble in testifying, then we are going to ask for medical, psychological reports or medical evidence to support how the client may testify or the problems they may have in testifying. And more importantly, we can ask for procedural accommodations based on those medical reports for our client. We can also ask to have medical reports that can say, you know, it would not be advisable to enter into these areas of questioning because it could trigger have an impact on the person's mental health. We succeeded in getting procedural accommodations for a client where we got the questions to be asked to the refugee claimant by the treating psychiatrist in the psychiatrist's office to ensure that if there were any triggers or anything, that the psychiatrist would be able to provide support for that person. And it was based on the psychiatrist's report that said you cannot, in a non-therapeutic setting, ask this client questions. It can explain, so as I said, you know, when we're looking at humanitarian compassionate grounds applications or deportations from Canada for whatever reason, we can talk about the impact on the person's health, mental or physical, of the removal from Canada. We would get the medical report to talk to that, and then we would add to it the documentary evidence on the availability of treatment in the home country. But the focus of the report is on the impact on the person's health, or the impact on another person's health that's related to this person who may be facing removal. It can be the basis of asking for an adjournment or a postponement for a hearing. Like I said, for procedural accommodations, and for what we call so the Immigration Refugee Board has what's called the Vulnerable Persons Guidelines, and that's where you can ask that your client be deemed vulnerable based on medical evidence and ask for procedural accommodations. One of the things that they tend to, you can ask for a female board member, you can ask for reverse order questioning. And what that means is that usually at the Immigration Refugee Board, the person who starts the questioning is not the lawyer, but the board member. And so if you want the questioning to be started by you, a person who's a familiar face, who knows the client and is going to put the client at ease, then you could ask for reverse order questioning based on the medical evidence. You could ask for frequent breaks. Like I said, we ask for the questions to be asked by the psychiatrist in a therapeutic setting and not by the board member. There's a number of accommodations that you can ask for. And the other thing that you can get with medical evidence is to have a designated representative appointed for that person. So any person that has a procedure in front of the Immigration and Refugee Board, be it any one of the 4 divisions, they automatically, so their designated representative is appointed for someone who's unable to understand the nature of the proceedings. A, because of their age, so anybody under 18 is automatically appointed a designated representative, or B, because of their mental or physical health. A designated representative is like a litigation guardian. Basically, it's someone who's supposed to assist you navigate through the system. As a designated representative, I can appoint counsel, I can fire counsel, I instruct counsel, and I'm basically working with counsel and the client in trying to assist them gather the evidence that they need to get through the process.
Yeah, just to piggyback on Laila's point. So, you know, we work really hand in hand with medical and mental health professionals to prepare these reports and ultimately support our clients. So usually the professional asks us what the purpose of the report is. Is it for a refugee claim? Is it for a humanitarian application? And we work with them to figure out what are the best, you know, accommodations, for example, that need to be put in place. You know, what are the challenges our clients are going to face in testifying, and try to strategize collaboratively on how to best support our clients through the legal proceedings. So if you do have a client who is going through an immigration proceeding, you know, it's really important, I think, to connect with their counsel to see what the medical evidence is for and how to best make that support. If for whatever, and this does happen, you know, again, for us in Ottawa at least, where the lawyer doesn't respond to the medical professional's calls or inquiries, you could certainly still call us or, again, one of the community legal clinics. And we think probably without breaching confidentiality, you can just sort of explain what the situation is, and we can probably give you a good idea of, you know, where they are in the legal context and what this report might be for. But obviously, it's best to discuss this directly with your patient's lawyer directly.
I mean, our practice when we approach a medical professional is to explain who we are, what the application is that our client is applying for, and to provide them, ask if they'd be willing to write a report. If so, we would provide them with some background information for the clients about the client's immigration status and the purpose of the report, and questions that we'd like them to address if possible. I often ask for the draft report so I can read through it and I can go back to the medical professional to discuss some of the stuff in the report. Like often if for psychological evidence, for example, you know, we've spent hours drafting the client's story for the refugee claim, and in their meeting with the psychologist, which happens after we've already submitted that document, more things may come to light. So it's a question of discussing it to see how to put that information in the report so as not to create a credibility issue for the client.
Yeah, exactly.
And as Nick says, like I often get calls from medical professionals who have been asked to ask for a report and they're not sure what the purpose of the report is. And it's pretty easy to have an idea without going at all into details about the client's story or your patient's story about where they are in the immigration, and or help them figure out what questions to ask the lawyer.
Yeah, that's a good point. Okay. So with all that said, we're now going to spend the last 10 minutes or so discussing strategies in preparing mental and physical health reports. So again, like these are just in broad strokes. It obviously depends on the client and the conditions and the legal matter, but we're hopeful that these tips will be really important, you know, giving the most probative value to your reports in immigration legal proceedings. Okay, so first and foremost, you want to explain your qualifications. Essentially, the decision maker wants to know why you're well positioned to give the clinical observations or the impact on the person's mental health. So you do want to explain your credentials or expertise in your medical report. If your profession is regulated, give your regulation number. And again, the goal is to convince the decision maker that you are positioned to provide the opinion that you're giving in your report. Some people also provide a CV, which is fine. Others just do kind of like a brief introductory paragraph about themselves. State how much time you've spent with the client. So this is a bit of a challenge. We obviously know there are lots of refugee claims happening. There are lots of demands on our services and yours. But decision makers, generally speaking, don't really like it when someone meets a professional, a mental health professional, for just one sitting for less than an hour, and then reaches the conclusion that the person, for example, has PTSD. So it's important to state how much time you spent with them, generally how many sittings have you had, how long has each appointment lasted. And it's especially important, again, to explain why you think you can reach the conclusion you have made based on the amount of time you've had with someone. Because basically what the federal court has said is the decision maker, let's say for a refugee claim, can decide how much weight to give to a report, but they are not the experts on mental health. So if you explain in your report, based on the number of hours I've spent with this person, I feel comfortable reaching this conclusion or this diagnosis, I think it's a little more difficult for the decision maker to say, well, in my opinion, you haven't spent enough time with them, but you absolutely do want to outline how much time you spent. Explain the diagnostic tools you're using. So again, you kind of want the decision maker to follow the bouncing ball. So you want them to understand that you're a professional, the tools you've used, generally speaking in layman's terms, what those tools are meant to diagnose. And again, why you feel comfortable reaching the conclusion or diagnosis you've provided based on the tools you've used. Essentially, you want to justify your conclusions. Again, this depends on a case-by-case basis, but you definitely want to minimize or avoid simply reciting the client's allegations of their experiences in their country. So your role as the health professional is to explain your clinical observations. Generally speaking, the reports do include a bit of a summary of the person's case, but you want to really stick to what the client has told you about their experiences. I usually suggest that you should focus not necessarily on what the client has told you, but what you've observed with the client in telling you about these experiences. So did they get tearful? Did they get forgetful? Was there a certain type of traumatic response in speaking about a certain subject matter? If your report is basically, this person fled domestic violence, they're afraid of domestic violence. If you're basically just reciting the person's narrative, then you're kind of giving the decision maker the opportunity to say, well, I found these experiences not to be credible, and the report is based on those experiences, so I give the report a little weight. Oh. Okay, and last but certainly not least, you want to stick strictly to your scope of expertise as a physical or mental health professional. So this is often a fine line that I find some professionals struggle with, but you really want to stick to what you know based on your qualifications. So for example, don't speak necessarily on the person's credibility. You can say something like, the person's, my clinical observations are consistent with someone who may have experienced, let's say domestic violence as an example, but you don't want to say this person is telling the truth on such and such things. You do not want to go into the risks of return to their country unless, again, it's based on your clinical opinion. So certainly speak on the impact of mental health, or, if the person, I'll just give you another example for a humanitarian application. Let's say one of the arguments is, if this person doesn't have these healthcare services, this is going to be the negative consequences on their physical health. You as a professional can say, this is my opinion on what would happen to the person's health if they don't have services, but you're probably not an expert on the availability of those services in that person's country or nationality. You don't want to say this person won't have state protection, this person will experience domestic violence. Again, you really want to stick to what's truly within your scope of expertise, because otherwise a decision maker may say, hey, your report sounds more like you're advocating for the person's case, or you're kind of, barging into my territory as a decision maker on the criteria I need to consider. So I'm going to give your report little weight for that reason.
And then just to add a couple of points. So in terms of the, if you're a physician and you've been asked to comment on whether or not someone's been tortured in their home country, again, you can't say, yes, so you get the story, they say they've been tortured. You can't say they've been tortured, but you could say something to the effect that these lesions are consistent with, what the person says, right? And so again, it's a question of speaking as to your expertise and what you know, and not getting into, I believe the person because of this. And then in terms of availability of services in a person's home country and the hardships or the risks they could face if they went back and they didn't have services. Remember that if any lawyer just asks you to focus on that the law is that there's two issues. It's the first one is whether removal in and of itself would have an impact on the person's mental health. And the second one is whether or not they would suffer hardships because of their mental condition in their home country. And that's where we look at what would happen to them if they didn't have those services, or what would happen to the person here in Canada if they lost their loved one. So if their loved one was deported from Canada, what impact would that have on their medical health?
Yeah, and just another point to chime in. So again, you need to stick to what's allowed in your profession. So sometimes we see, for example, psychotherapists who are diagnosing individuals with PTSD. So that's also really important to keep in mind. So you can say something like, this person has symptoms akin to PTSD or this other form of trauma or condition, but you really have to be careful and have nuanced language similar to those physician reports that Laïla was just talking about.
And another thing that's really important is, I don't know, I'm not a medical profession, so I don't know what the impact on a person's health may be, or the impact of what what an impact can be on their testimony. But if I ask, I would need an honest opinion from you, because if there is no impact, then I'm not going to waste my time arguing the case, right? Like, your opinion and your credibility as a professional for me is really important, because I'm going to be coming back to you to ask you for reports. So I don't want you to go out of your area of expertise, and I certainly don't want you to put anything in there that you don't professionally believe.
Yeah, like obviously put what you're comfortable putting in the report. It's really important.
I remember once I had
Go ahead, Laïla.
Sorry, I had a client who was in detention and we were trying to get her out, and she consistently changed her story, like so consistently that at one point I asked the psychiatrist, is there a medical reason behind this? And he said, no, she's just a chronic liar. And I was, okay, well, let's not put that in the report. Right. And that was it. Like, I don't know. So I was, generally asking for information, and I very much appreciated the candor and honesty.
Thank you. Yeah, this has been great. This has been a very informative session. I know I've learned a lot about immigration law and its role with our audience today, and it's been very informative. And so we have some questions now with regard to it. But first one that I actually had was, have there been situations where you've had to go through, say, the health records department and privacy officers in order to get the information before being able to add it to the assessment?
To add it to the what, sorry?
To their assessment, their prop.
Well, so for different applications, we may or may not get the medical records. Sometimes we don't have enough time. Where we do
Right.
have time, we try to. I'm not going to be submitting anything in support of my client's application that's not helpful. I believe that if we have medical reports that back up with, like if a psychiatrist or a physician writes to me and says, this is my medical opinion, this is, this is their diagnosis, and that's all I need, right? Sometimes if we can get it, it's helpful. I don't know, Nick, did you want to add anything?
I mean, certainly if there are medical records, we'll try to get them. They can certainly be helpful. Again, if we have, I mean, this isn't ideal, but like, let's say we have someone who we think has PTSD, or someone who, because of trauma, like really does not remember key events in their life. I have a case right now where the psychiatrist, because it's actually someone outside Canada, she just doesn't have the time to like write a report explaining this. So in this case, what I've done is I've just tried to get her medical and mental health records, and then I'm getting someone here to basically do an opinion letter saying, I've looked through these records, I've read through the person's narrative. In my professional opinion, this person, may have symptoms, akin to PTSD. And one of the things about PTSD is you may not remember certain key events in their life. So it's a bit of a more nuanced assessment, because this professional can't say, my opinion is this person has PTSD and this is why they're forgetting things. It's better if it comes to the person who personally does the assessment. But like Laïla said, I won't submit anything unless I reviewed it. Yeah. So.
The other thing about medical reports, Andrew, is that a lot of our clients don't have access to medical health coverage. So because they don't have access to medical health coverage, they haven't gone to the hospital, or they don't have a physician or a doctor. So where they're in crisis and they've been to emergency, then yeah, there may be some medical reports, but a lot of our clients don't necessarily have it. And a lot of our clients may not be aware of a medical issue that they have. So because they haven't had the medical examination, because they haven't gone to a doctor. So people, we represent a lot of people who are without status here in Canada. A lot of them haven't been to see doctors, right?
Well,
and so
yeah. Well, I was going to say, even if they have access to healthcare services, even if they have insurance, I mean, we can talk all day about this, but like the concept of mental health, obviously it's still quite stigmatizing in Canada, but for a lot of our clients, it's such a foreign idea. They've never heard of mental health, or they think it's associated with like a witch doctor. So we sometimes have clients that have, for example, phantom pains, or, they have trouble sleeping at night, they have nightmares, and it never crossed their mind that it's something related to trauma they experienced, or something that, can be addressed with proper mental health care treatment. So there's that barrier as well that, often we have to unpack and address with our clients.
Right.
And there's, just to add, we work in a community legal clinic. We provide our services free of charge. You can't always get reports for your client, especially if it's, your client doesn't have a treating physician, that are affordable.
Right.
Like the costs of our clients can't afford them, right? So
yes,
it can be prohibitive. It can have an impact. So in those circumstances, if we can get the hospital records, if there are some, it's a lot easier. Most medical professionals are very kind and are willing to do reports, and are even willing to either for free or within our financial resources. But sometimes we just can't get them.
Right. Of course. We have the following question here. Has COVID-19 created challenges to any of these procedures that you've discussed today? And would you be able to give any examples, and where there are any mitigation procedures implemented by the governments, by LAO, et cetera?
How much time do we have? I mean, the short answer is yes. COVID has disrupted our clients' lives and legal files in our lives. So.
Yeah. I mean, one of the biggest things is that it became like, immigration, it's 36 months to get a decision on an H&C is quite scandalous. I don't know if you've heard the news about this woman who has children in, what country was it? Jackie's case?
Oh,
the woman who was who's found to be a convention refugee, whose kids are in Gaza, if you make a claim for refugee protection, you're accepted, you can then apply for permanent residence as a convention refugee, and you can include your children in that and your spouses that are overseas. And so it takes 24 months to get permanent residence, and then they will get the children over and the family. So that length of separation now with COVID is, forget it, like 24 months is nothing.
Yeah.
And scandalous, like people who made a claim for refugee protection in Canada were in limbo for 1 whole year because they suspended all of the eligibility interviews, right? They've now started doing virtual hearings. So, we fought forever and a day to have in-person hearings because credibility is so crucial. You have to understand that they're determining credibility for people with language barriers, maybe medical barriers, cultural barriers, and then you're adding the distance of a video camera. Some of our clients, we can't get in touch with them because they don't have access to internet, they don't have access to phone, like getting people to print documents and forms and sign them. All of this has had a huge impact on our clientele. The only good thing that I would say that the government did is they've introduced a couple of new pathways to permanent residence that to speed up or to provide people who are in Canada with an opportunity to apply for programs that didn't exist before.
Great. Thank you. So we also have the following question. When a newcomer comes to Canada on a closed work permit, employer specific in a rural area, it's typically for larger companies that pre-COVID recruited from different countries. During COVID, many lost hours, employment altogether. How do service provider organizations support newcomers and small business owners who have employment opportunities for this demographic, but are not aware of the processes such as applying for certificates for registration within the province and an LMIA with Canada? And like you said, the process can take months. So does the federal government offer any kind of support or program at this time for employers to fill open positions and TFWs to get hours they need to make ends meet?
Yeah, so that's a bit outside our scope of knowledge. we don't do a lot of work with the Temporary Foreign Workers Program, or LMIA.
Okay.
But for those that don't know, LMIA stands for Labor Market Impact Assessment. And the way, at least I understand it, when another lawyer explained it to me, is it's basically when an employer wants to hire you, they need to show to the federal government that no Canadian can do the job. But there's been a chronic challenge for temporary foreign workers in gaining permanent resident status because those work permits are usually valid for 1 year. It used to be that after 4 years, you just couldn't renew it, even if employer wanted to hire you. As Laïla mentioned, there was, the government has created some new pathways for people inside Canada. And I know some of them included, some positions, like janitors and some other ones that didn't require a high level of education that, created this path. But there are other barriers like costs, language, there are caps on those programs. So yeah, I agree generally. I can't get into the nitty-gritty because it's not something we practice, but there do need to be more options to give temporary foreign workers
I would say
PR status.
Yeah, I would say that for if you're in Ontario, I would get the temporary foreign worker, not the employer, to contact a community legal clinic, especially in areas where they have a lot of temporary foreign workers. Those our colleagues in those clinics are much more aware and do a lot more with the TFW programs. And if you're not in Ontario, contact the legal aid services of your province to find out what they do, if they do cover immigration services, and if so, what type. Also, the Law Society in Ontario has a lawyer referral program where you can call and get half an hour free legal advice. You can Google that, and I don't know for other provinces, but I would think that I would contact legal assistance for those clients.
Thank you. And to add to that, we will be hosting a webinar on temporary migrant workers nearing the end of August as well, just to add to the statement. So for the attendee that asked that question, check out our webinars as well. So we have this question. I have a family who are in Canada who are under temporary visas, study permits. One member of the family is suspicious for a brain tumor. He's refusing to go get treatment because of the fear of PR rejection. As a healthcare professional, I found this similar scenario happening a lot and causing moral distress for us. How discriminatory is the immigration system? What is the future approach to provide more equitable system for all? So this might be a blue sky question in general, but.
So, I mean, what I would tell your patient is that even when they apply for permanent residence, they will have to do an immigration medical examination. So not going to get tested and not taking treatment is not going to get around it, because when they apply, they will have to do a medical examination. And like I said, you will get a procedural fairness letter, and there are ways of getting around that potential inadmissibility.
Yeah. And again, just to reiterate, so you can be inadmissible for medical grounds if you have a condition that costs the healthcare system about $20,000 a year. So it's something to look into, and there's a way to get around it. But, you know, there are advocates that rightly say this section of the law is highly discriminatory and could be subject to a charter challenge based on disability.
And
yeah.
Yeah, and interestingly enough, whenever a lawyer has tried to raise that as a ground, the government has settled the case because they don't want the full charter challenge. There was one woman that did it a couple years back, and I don't know. But we completely agree that and more advocacy needs to be done at a political level in terms of how discriminatory this is and ridiculous.
Yeah. But just kind of bring back to the point before, like if someone like that is in a legal conundrum, you know, I would absolutely contact a community legal clinic to see if, you know, that person should do a humanitarian application, or if they're here on a study permit. I know you get, at least in Ontario, something called UHIP, which is kind of like the equivalent of OHIP. And if there's a path to permanent residence that way, but it's an understandable concern. I would feel the same way if I had a child with that, but you know, avoiding getting the medical treatment isn't going to solve the legal issue.
It might make it worse because the longer you avoid it, the less you get treatment. It could have a bigger impact on the health.
Right. Thank you. Thank you. Yes. So we have the following question. If a refugee claimant has a child with a disability and the parent receives assistance for children with severe disabilities, ACSD, or special services at home, SSAH funding, to assist with the cost of caring for their child, can this impact their refugee hearing decision?
No. No, so a refugee claim is based on the criteria that we outlined. I mean, we'd have to kind of go into details if maybe the impact of removal, you know, maybe has an effect, but it wouldn't be a detriment to their refugee claim, I would say.
Yeah. The board is not going to look at the person's medical health in terms of whether they should be found. Let me rephrase that. They're not going to refuse somebody because they have a mental or physical health condition. The medical or physical health condition is relevant, as we said, to try and get procedural accommodations and to try and to assist with any credibility concerns. And the medical may be a ground for, to ground the claim for refugee protection. So I'll give you an example. We have a client who made a claim for refugee protection based on political opinion in his home country, and he suffered a severe, he had a brain tumor. And he's now fairly disabled. And so we're going to add the discrimination on the basis of his disability as a ground for refugee protection, because in that country, it's clear that he will face persecution as a person that's disabled.
Yeah. Where health evidence is also relevant is an internal flight alternative, which was that last criteria I mentioned. So even if you wouldn't risk persecution in another part of your country, is it reasonable? And one of the things to consider if it's reasonable is access to health services that you need. So if you have a disability and there's clear, you know, information that you're not going to get care for it, then that can go to the reasonableness of that potential internal flight alternative.
And then as Nick mentioned when he was giving his presentation on medical inadmissibility, it doesn't, if you're found to be a convention refugee by the Immigration and Refugee Board, the fact that you or any family member has a medical illness that could put it, that you can't be found medically inadmissible as a convention refugee.
Thank you.
And
Go ahead.
Sorry, just to say, because we use the term convention refugee and refugee, a refugee claimant is someone who's made a claim for refugee protection, and a convention refugee is someone who's been found to be a refugee according to the United Nations convention definition.
Thank you. Thank you for that clarification too. What measures, if any, are taken to protect identities and preserve the well-being of highly vulnerable groups? For example, the Uyghurs, who seek refuge in Canada, or any groups that are at risk of potentially returning and potentially threats of genocide, for example.
I'm not sure I understand the question. So us as legal clinics, what efforts do we make, or the refugee board or immigration?
I believe it's just with regards to the applications, with regards to the those elements.
So refugee claims, because a person is alleging that they would fear persecution if they went back to their home countries, they're not public hearings, they're in camera. The same thing when you make a claim for, when you apply for a pre-removal risk assessment, you're alleging that you would have a risk in your home country. So they're not publicly available in that respect. The only thing that you need to know, that a client needs to know, is that if they're refused, and let's say if they've had the appeal before the Refugee Appeal Division and that's been refused also, they can bring an application for a judicial review of that decision before the Federal Court of Canada. Those are public hearings and publicly available documents. So the lawyer would need to bring an application to have it anonymized or confidential.
Thank you. So we have one final question. When you contact the medical providers, do you secure a written consent from the patient to share that information?
Yeah, we always get authorization from our client to approach the medical professional and to provide their background information before we contact the medical professional.
Thank you. Thank you.
Yeah, and vice versa. So we also get our clients' consent for us to talk about their legal case with their medical professional.
So they sign an authorization to release information.
Yeah.
Right. Great. So we do have a few more minutes left, and one more question just came in. For yourselves, what made you specialize in this area of law?
So I have a background in development, and I was working for the United Nations Development Program as a junior professional officer looking at environmental and aid programs in Cape Verde off the coast of West Africa. And while I was there, there were four young men who were refugees from Sierra Leone, I think, who had been in a refugee camp in the Côte d'Ivoire and who had decided they wanted to go to the US, the land of opportunity. And so they had stowed away on a boat and got discovered in Cape Verde and got hauled off the boat in Cape Verde. And because the United Nations Development Program mandate is to cover the agencies that are not physically present in Cape Verde, and because there are no refugees in Cape Verde, we were in touch with them. And as a Canadian, and when there were like no resources, no services set up for them. So we tried to get them jobs, and I got to know them very well. And they wanted me to help them apply for a passport, and they wanted me to help them apply for visas for the US. At the time, the US wouldn't even take applications. They wouldn't even give them the forms. And that's when I realized that that's when I started getting interested in refugee law. And I'm Egyptian of origin, but I have a Canadian passport and can travel everywhere. But a lot of my cousins and stuff don't have the same opportunity because they only have an Egyptian passport. So it was a combination of both. And I love my job. I get to work.
I mean, I always had an interest ever since I was younger in human rights and social justice work, and also like learning languages and exploring different parts of the world. So when I was, I think around 20 years old, I got a job teaching English to foreigners. And so it was a great way to meet people and do a job that I was way too young to qualify for, really. And, you know, when I actually, my undergrad, I think I changed my major like 7 or 8 times, and I changed school 3 times. But anyway, when I finally ended up in Canada, because I'm originally from New York, my major was in international relations. So involved some human rights, some economics, philosophy, political science, this and that. And I had always wanted to avoid law school because my friends' parents who were lawyers seemed really miserable.
Lawyers were all crooks.
Some of them aren't. I mean, I know at least one, but yeah. So, and I mean, I also specialize in LGBTQ refugee stuff. So there was also some personal experience related to that. But anyway, before law school, as I mentioned, I was teaching English and then later French with foreigners throughout my undergrad. But right before law school, I was teaching at a school in Atlanta, Georgia for newcomers, for refugees. So some had like just arrived within a couple of weeks, some had been living in Atlanta for 20 years. And not only they were working, you know, 2 jobs and raising kids, they were coming to English class like 6 p.m. to 10 p.m., Monday to Friday, no complaints whatsoever. And, you know, I thought, you know, what's a way I can be, I guess, more involved in, you know, in their journey and, you know, settling in Canada or the States. So at that point, I had already applied to law school, but it really sealed the deal for me. And once I got into law school, I did, you know, any and every opportunity in refugee law, and I've never regretted it.
Awesome. Yeah, thanks. That's very interesting, very inspiring too. So just to wrap up with the last 5 minutes, I'm just going to share my screen. And so I very much want to thank Laïla and Nicholas for taking time to present in today's webinar. I know that I've learned a lot about immigration law, and you've been very helpful in providing a lot of information today too. So thank you for that. And a thank you to you, the audience, for joining us today. And you're welcome to join us for any future webinars that we have coming up, including June 9th. We're discussing intercultural dialogue, bridging the gap between newcomers and Indigenous people. And on June 23rd, we have Immigrant Refugee Services for SOGIE, Diverse Newcomers, coming up with Kelly Ernst from the Center for Newcomers in Calgary. Following today's presentation, you'll be invited to complete a survey to share your feedback with N4. These surveys help us continuously improve and seek new webinar content and opportunities that are responsive to the topics that you, as N4 members, are interested in. We kindly ask that you follow the link and complete this brief survey after the webinar has concluded. If you missed any part of today's presentation or would like to watch this session again as well, we'll be posting the recording to the N4 platform within the next week or so. Our speakers will also be answering any questions related to the webinar for up to 10 days following this webinar in the meeting place on the N4 platform. So if you have not, please sign up to newcomernavigation.ca for access to our many resources, webinars, and our meeting place, and much more. And before we sign up, are there any final messages you would like to add, Nicholas or Laïla?
Thank you very much for having us.
Yeah, thank you. Hopefully this was a valuable opportunity to learn about immigration law.
Oh, that's great. No, yeah, it was very valuable. So thank you so much. And thank you, everyone. We will see you online again at a future N4 event. Take care, all.
Goodbye.
Bye.